Namaste and welcome to another edition of Legal Words of Wisdom, Nyay Ganga, on our Virat Hindustan Sangam social media channels. As you know, we have this program on every Saturday at 8 p.m. Indian Standard Time, and we are back today to discuss a very interesting topic, rights, duties, and their enforcement. And as usual, we have Dr. Subramanian Swamy and Dr. Venkat Iyer, who will be discussing the topic of rights, duties, and their enforcement. As you all know, Dr. Venkat Iyer has been hosting this program since its inception, and today's is the fifth episode. Dr. Venkat Iyer is a barrister and he is a mediator and legal academic based in the UK. He was originally in India, was at the Mumbai bar of the Bombay High Court, and then he moved to UK. So with this, we are today taking this issue of getting the common man to understand legal law and other aspects of law. We are going to be discussing the rights, duties, and their enforcement. Today, we will be discussing the connection between the fundamental rights and the directive principles listed in the Constitution. Is a clash between them inevitable? How useful is a chapter on fundamental duties? What is meant by the basic structure of the Constitution? Had judges become too powerful? These are some of the topics Dr. Venkat Iyer would be discussing along with Dr. Subramanian Swamy. So I welcome both Dr. Swamy and Dr. Venkat Iyer to this show. Our regular Sunday show will be there at 8 p.m. tomorrow. I thank my co-host for this program, Ramesh Swamy, and the technical team led by Ashish Shetty, Vishal Mehta from Mumbai, Ishwar Iyer from Navi Mumbai, Tejas from Pune, Swaminathan from Chennai, and Rakesh Gadgi from Bangalore for their support to put this weekly program on Saturday together. So with this, I would request Dr. Swamy to start his initial remarks, and then it will be over to Dr. Venkat Iyer. Thank you, viewers, for your support.
Well, thank you very much. Today is a very important session from the point of view of what people must know to be good citizens. The law is usually made by Parliament, but the basic principles under which law can be enacted and cannot be enacted is laid down by the Constitution. In the Constitution, there are four parts which are very important in interpreting laws. One is called the preamble. And the preamble, lays the boundaries of laws. For example, the preamble says faith. And faith is, enshrined as a part of the preamble, which means that you cannot make laws or you cannot interpret laws to challenge faith. Faith is to be accepted as it is. So if the Christians say that Jesus Christ was born in Bethlehem, nobody saw him being born there, but it is taken as faith and it is accepted and it cannot be challenged. And if it is challenged, then it becomes a violation of the law. For instance, we have a law section of the Criminal Procedure Code, a section of the Indian Penal Code, section 295, which says that if a substantial number of people have have faith that something is sacred, then it has to be treated as sacred. No court can decide what is sacred, what is not sacred. And so I will first point out that in the Constitution we have the preamble, which lays down certain key concepts which are taken without question. Then there is something called fundamental right. That is, you have certain rights which cannot be taken away by law, amended by law, or moderated by the law. So that's called fundamental rights. Then there is something called directive principles, which lays down what the government must do. That is in called directive principles of the Constitution. For instance, Article 48 says that slaughter of cows is prohibited, and that has to be therefore a part of the law. It hasn't been yet made as part of the law in most states, but it is there. Banning the drinking of alcohol, alcohol drinks commercially, that's also there. Uniform Civil Code, that's also there. And so directive principles are not justiciable in court by an individual, but it is the principle of, it's a compulsory principle of governance, and the governance is required for that. And finally, you have something called duties, which lay down what every citizen has to perform, but there is no way that can be enforced. It is a guiding principle in court cases. It's a guiding principle in deciding whether something, it's a kind of an additional argument when you're making some other argument. You can draw on the duties concept. So in these broad terms, I have talked about rights and duties, and in the principle of governance. And so now for details and a sharper presentation of the subject, I'll ask Professor Venkat to take over.
Thank you, Swami. I had actually intended to talk about something else this week, but it occurred to me that the subject of rights and duties can do with further exploration, not least because there were a couple of things that you, Swami, brought up in the brief discussion we had at the end of last week's program, which are very pertinent to understanding how rights work in practice under the Indian legal system. I've therefore decided to devote this lecture to three major issues. First of all, the connection between fundamental rights and the directive principles of state policy, which I shall, for convenience, refer to simply as directive principles. Secondly, the usefulness and the relevance of the chapter on fundamental duties, which was not an original feature of the Constitution. And thirdly, the important but slightly problematic concept of the basic structure of the Constitution, an understanding of which I think is indispensable for an understanding not only of rights, but of various other aspects of the Constitution. Taking directive principles first, these are, in simple terms, a set of guidelines provided in the Constitution for the government to follow in making law or in formulating policy. They are to be found in Part 4 of the Constitution, the part which immediately follows the fundamental rights, and they are borrowed from the Irish Constitution. There are about, I think, 18 such principles, including a few which were introduced through constitutional amendments. For the most part, these principles are non-controversial, and they include such things as securing a social order which promotes the welfare of the people, securing equal pay for equal work carried out by men and women, promoting an adequate means of livelihood for everyone, promoting access to justice and legal aid, trying to make work available to everyone, promoting cooperative societies, working towards a uniform civil code for all citizens, promoting the economic interests and welfare of scheduled castes, scheduled tribes, etc., protecting and improving the environment, organizing agriculture on modern lines, and prohibiting the slaughter of cows and milch cattle, to which Swami has made reference already, promoting international peace and security, and so on. I've, of course, not covered all the directive principles, but just given you a flavor of what is involved. I mentioned a minute ago that most of the directive principles are non controversial, but that does not mean that the principles have not presented difficulties in implementation. They have, and at one time they became a major battleground in political and judicial discourse. There were two main areas of contention. The first was in agreeing about the meaning and the implications of particular directive principles. And the second, even bigger problem, was in deciding where these principles stood in relation to fundamental rights. And these are not academic questions, they have serious practical implications. Within the time constraints that I am under, I shall try to deal with both in turn. First, taking the issue of the differing interpretations that can be given to many of the directive principles, one needs to recognize a general challenge in law, and that is that there are limits to the use of language. In the first place, words have different meanings which depend on the context in which they are used. This can lead to arguments about correct meanings that can be attributed to particular words. And secondly, there's only so much you can say in a law without making it unmanageable or unduly cumbersome. As a result, it is impossible to avoid the need for interpretation of laws in any society, however well crafted those laws may be. The point I want to make is that many of the directive principles are open to divergent and even contradictory meanings, which makes reaching consensus on them difficult. Let me give you a tangible example. A prominent directive principle is to be found in Article 39B, which says, among other things, that the state shall try to see that the ownership and control of the material resources of the community are so distributed as to subserve the common good. The next clause in the same article enjoins the state to avoid concentration of wealth to the common detriment. I'm, of course, paraphrasing. The actual wording is much longer. Now, there are different ways in which those objectives can be achieved, for example, through the operation of a free market economy or an economy that relies on nationalization and centralization. Nowhere does the Constitution say that one is preferable to the other. How is one to make the choice in those circumstances? I would suggest that in a democracy, those kinds of choices are made by governments who are elected on the basis of what they state in their election manifestos. If a majority of people find that the policies advocated by Party A and not those advocated by Party B to be more attractive, then they would choose the former. And if at the end of its term, Party A fails to deliver, then the people have the choice in the next election to throw it out and choose Party B. Such flexibility is needed to run modern societies, and the constitution makers, in their wisdom, decided to include a list of objectives that every government should seek to achieve, but couched those objectives in fairly general terms and left open the methods through which those objectives would be achieved. A bigger battle was about the relative importance of directive principles vis-à-vis fundamental rights. Successive governments, notably those headed by Indira Gandhi, strenuously argued that the directive principles should stand higher than fundamental rights because, they said, rights favor the well off, whereas the ideals enshrined in the directive principles touch the lives of the poor and the downtrodden. No effort was spared to pit one against the other and to argue for a revolutionary change to the settled constitutional position, which was that the directive principles should remain unenforceable, unlike fundamental rights. The correct and sensible view of the matter, and this is what the constitution makers accepted after a lot of debate, is that the directive principles are the ends which every government must aim to achieve, whereas fundamental rights are the means for achieving those ends. It would strain credulity to argue that there's a clash between those ends and means. Directive principles and fundamental rights are on different planes. Directive principles are, in one sense, like aspirations or goals or targets which have to be realized progressively and subject to the availability of resources. In a poor country, giving everyone a legally enforceable guarantee of work would be unrealistic, and there will not be sufficient resources to compensate every unemployed person with what is traditionally called the dole. That is why directive principles were made non enforceable, while fundamental rights could be enforced through the courts. That crucial point was unfortunately lost on a lot of the left wing demagogues who occupied positions of power in the 1970s and 80s. And unfortunately, even today, there are many people, especially in what I would call the human rights and development industries, who misguidedly believe that directive principles are more important than fundamental rights and that they should therefore be made legally enforceable. But the good news is that that mischief was put to an end judicially in a case called the Minerva Mills case, which was decided by the Supreme Court in 1980. I may, time permitting, return to that case later on in this lecture in a slightly different context. But I want you to remember that giving priority to the directive principles over fundamental rights was one of the many outrages that were perpetrated by the notorious 42nd Amendment to the Constitution, which was passed during the spurious state of emergency declared in 1975. I now want to move on to the second major issue that Swami had raised at the end of last week's lecture, which is the implications of the chapter on fundamental duties, which was also a creature of the emergency. Now, viewed in very general terms, not many people will or should have any objection to a statement of duties in principle, because, as I said in my last lecture, rights and duties go together in all civilized societies. But the chapter on fundamental duties, which is part 4, capital A, was introduced more as a gimmick, a political gimmick, a smokescreen, and a diversionary tactic than anything else. For a start, the idea of fundamental duties, as conceived by those who were keen to add it to the Constitution in 1976, was borrowed from the Soviet Union, and it therefore came with a certain amount of ideological baggage. The background to this reform was that there was growing unrest throughout India over the emergency regime, and this was sought to be portrayed by Indira Gandhi and her supporters as indiscipline among the masses, which of course needed to be put down. There was, it was argued, too much emphasis on rights and too little on duties. One of Mrs. Gandhi's left leaning acolytes, her law minister H.R. Gokhale, mooted a legal solution to the problem, and another of her henchmen, her foreign minister Swaran Singh, gave concrete shape to that idea in a report which was rushed through without too much consultation. That report suggested 8 fundamental duties which every citizen should be required to discharge, failing which he or she would be subjected to such punishment as Parliament may by law prescribe. The report in question also recommended that any such law would be immune from scrutiny by judges. Now, those recommendations were quickly legalized through the 42nd Amendment, but with a couple of changes. The list of fundamental duties was expanded to 10, and no punishment was suggested for non compliance. A lot of rhetoric, of course, accompanied the passage of the amendment. The duties themselves were, on the whole, unexceptionable. I would say largely in the nature of motherhood and apple pie, and they were couched in fairly general terms. To that extent, you could consider them harmless. But if they had been made legally enforceable, they would have caused trouble. Among other things, they required everyone to uphold and protect the sovereignty, unity, and integrity of India, to value and preserve the rich national heritage, to safeguard public property, and to abjure violence. But there were some tricky ones. For example, there was one fundamental duty which said that everyone has to render national service when called upon to do so. This suggests the possibility of compulsory conscription, which is not national policy. If the fundamental duties had been made legally enforceable, that provision would have caused difficulties. Another interesting duty that has been prescribed is to develop a scientific temper. Again, entirely innocuous, but I've often wondered how that would play against the widespread Indian belief in things like astrology. I'm reminded of what one prominent and, I might add, populist former Chief Justice of India said in a widely publicized interview given a short while before his death. This judge, who was known to be an ardent devotee of a controversial god man, also now dead, proudly proclaimed that every judgment of his was dictated by the god man. Not very different, one would say, from the actions of one of Burma's notorious generals who decided whimsically to move the capital of his country from Rangoon to Naypyidaw at enormous cost a few years ago, simply because his astrologer had warned him of impending personal disaster if that step was not taken. The next important issue which I want to discuss is the concept of the basic structure of the constitution and the impact that it has had on public life in India for the nearly half a century actually, for which it has been in existence. In simple terms, what this concept means is that there are certain fundamental features of the constitution which cannot be altered, much less abolished, no matter how big a majority there might be for such alteration or abolition in parliament. You can view the basic structure theory either as a challenge to democracy or as a safeguard against the tyranny of the majority, depending on your taste. Now, the general rule in parliamentary democracies is that for any measure to become law, it has to be passed by more than 50% of MPs. And I'm, for the purposes of the present discussion, ignoring special majorities that are required for certain measures. But that view frequently comes under strain because there are issues where the views of MPs are very different from the views of the people they represent. I shall give you a couple of examples from the UK, where, as I've told you before, Parliament is supreme and there is no written constitution the way that you know it in, say, India or the US or France. Until a few years ago, whenever a vote was taken in the British House of Commons over the death penalty, then a massive majority of MPs would vote against capital punishment. At the same time, every opinion poll conducted outside Parliament indicated that an equally massive majority of ordinary people favored the death penalty. The contrast in attitudes could not be starker. A more recent example is what happened in relation to Brexit. As you know, a majority of British people voted in favor of Brexit in a referendum that was held in 2016. But every time this issue came up in the British Parliament, a majority of MPs expressed their opposition to Brexit. The point of my bringing up these examples is to highlight that there's always a possibility that if you go only by the principle of democracy, you can end up by creating a situation in which the rights of minorities, especially unpopular minorities, may be at risk of being trampled upon by majorities. And that risk is especially serious when populist politicians are elected and MPs are subjected to the whip of political parties. One method by which this risk is averted for certain is would be for certain guarantees to be inserted in constitutions under which certain rights, which are usually called fundamental rights, are insulated from being chipped away or eroded or abolished by parliamentary majorities. Now, that formula was adopted by the draftsmen of the Indian Constitution, and they inserted a clause, which was Article 13, which said that the state shall not make any law which takes away or abridges any fundamental right, and that any law made in contravention of this prohibition would be void. You can see how important this article is because it has the potential to keep certain basic rights away from what I would call the grubby hands of unscrupulous or self serving politicians. But that safeguard did not prove as effective as the constitution makers had intended it to be. Within a few months of the coming into force of the constitution, the government of Jawaharlal Nehru began chipping away the fundamental rights by introducing the First Amendment, which, among other things, curbed freedom of speech, brought in caste based reservations in government jobs and education, curtailed the right to property, and worst of all, created a new class of laws which could not be challenged, much less struck down, even if they were unconstitutional. Such laws were completely immune from scrutiny as long as they were included in the ninth schedule to the Constitution. The First Amendment was the starting point of a destructive trend, which over the next 2 or 3 decades resulted in the Constitution becoming a shadow of its former self. The high drama which surrounded the passing of the First Amendment is described vividly in a book by a young scholar called Tripurdaman Singh, which came out just a few months ago. I would ask any of you who are interested in the subject to read that book, an image of which Ramesh will display on the screen. What happened subsequently can best be described as a cat and mouse game. Whenever a law which sought to curb freedoms was challenged in the courts, and there was no dearth of people willing to mount those challenges, the courts would often strike them down on the grounds that they were unconstitutional. The immediate reaction of Parliament would be to pass constitutional amendments to nullify the court orders, and those amendments would increase the range of laws which could be shielded from further judicial scrutiny. In the course of this short lecture, I won't be able to list all those cases which became a test of strength between Mrs. Gandhi's government and the Supreme Court, but I can assure you that even if you're not a lawyer, you'll find them fascinating. Those were the days, incidentally, when the Indian Supreme Court had some very learned judges who had the intellectual capacity, not to mention the courage, to grapple with the complex issues raised in such cases. For those of you who are interested, I would recommend the writings of Nani Palkhiwala, which have now been brought together in various collections. If you're looking for more journalistic material, you can turn to the articles that have been written over the years by A.G. Nurani. I bring this up because in the feedback that I've received to these lectures, there were some requests for pointers to books and articles. As I said earlier, there were many landmark cases which dealt with the importance that needed to be attached to fundamental rights in the face of increasing parliamentary determination to curb those rights. Two of the big ones were the Golaknath case, which was decided in 1967, and the Keshwananda Bharati case, which was decided in 1973. Very briefly, what happened in the Golaknath case was that the Supreme Court ruled that fundamental rights could not be abridged, which of course was consistent with the constitution as originally enacted. But that raised the hackles of Mrs. Gandhi's government, which responded with a number of even more outrageous constitutional amendments, including the 25th Amendment, which subordinated fundamental rights to the directive principles and turned the constitutional scheme upside down. Those amendments were challenged in the Keshwananda Bharati case, which is better known as the fundamental rights case, in which the Supreme Court decided that whatever be the compulsions of social justice or economic reform, the government and parliament could not bring in any laws which would have the effect of destroying the basic structure of the constitution. This was, of course, a major blow to the government, which retaliated immediately, first by punishing some of the judges who had delivered the majority judgment through bypassing them for promotion to the office of Chief Justice, and then by repeated verbal attacks on the judiciary, which grew increasingly shrill over the coming months. In the meantime, Mrs. Gandhi suffered a personal defeat at the hands of the judiciary when she was declared guilty of corrupt practices by the Allahabad High Court, and that led to the dubious state of emergency of June 1975. That verdict in turn led to another controversial amendment, constitutional amendment, which was the 39th Amendment, which sought to annul the Allahabad High Court's judgment against Mrs. Gandhi. Much worse was, of course, to follow. Of particular notoriety was the 42nd Amendment, which bulldozed a series of major changes, some of which had the effect of altering the constitutional landscape completely. Lack of time prevents me from dilating further on this, but I've already made references to some of the obnoxious features of the 42nd Amendment earlier. In the remaining time, I want to talk a little bit about the basic structure doctrine. Superficially, it is an attractive concept, and it certainly served its purpose in the context in which it was first propounded. But it has been subjected to certain criticisms, both in principle and in practice, and those criticisms cannot be ignored. A fundamental objection to the doctrine in principle is that it goes against a basic tenet of democracy by serving as a veto against a duly elected majority in parliament. But this objection has been overcome by the argument that parliamentary majorities are not truly representative of the people at large, because typically no more than 50 to 60% of the people vote at general elections. And out of that, the majority party gets only around 40% of the votes, which means that the popular support enjoyed by those pushing through laws is rather small as compared to the size of India's population. In practical terms, the main objection is that giving a veto power to unelected judges is undemocratic. This is especially so where the judges are either incompetent or unrestrained or both, as is sadly the case with many judges in contemporary India. And I haven't incidentally said anything about corruption yet. But in a political system with a written constitution, which was drafted after great deliberation and which contained strong limits on what parliament can do and cannot do, that argument probably becomes rather weak. A more persuasive political argument is that the basic structure doctrine results in unpredictability about what may be contained in it. Some of the basic features are self-evident and, I would say, uncontroversial. For example, the democratic republican form of government, which means that India cannot be converted into a theocracy or a monarchy. Others that have been justified in successive judgments include judicial review, including of constitutional amendments, the federal structure of the polity, the unity and sovereignty of India, separation of powers between the legislature, executive, and the judiciary, free and fair elections, fundamental rights, and so on. But a lot of the time, problems arise in interpreting and giving detail to broad, non-controversial features. to offer you a stark and worrying example which has caused a lot of grief and which continues to bother many people even today, let me talk briefly about the provisions concerning the independence of the judiciary, which has rightly been identified as a basic feature of the Constitution. No one will seriously question the need for judicial independence, but that concept has unfortunately been given what I would call a dangerous spin in India in the past couple of decades to turn it into judicial supremacy. You can see this in the way appointments to the High Courts and the Supreme Court are made today. The Supreme Court has, after turning on its head the constitutional provisions which require the executive to consult the judiciary in the matter of those appointments, claimed for itself the upper hand in those appointments by holding that the word consultation means concurrence. It even rejected a system under which a relatively independent mechanism for judicial appointments was mooted. I'm now referring to the NJAC, the National Judicial Appointments Committee, with the result that the government is now made subservient to the judiciary in the matter of choosing judges. This, I don't think, can be healthy for any democracy in the long run. So, if I were to summarize this brief discussion, I would say that the basic structure doctrine, which began as an innocuous and maybe welcome antidote to the tyrannical actions of the Congress governments of the 1960s and 70s, has now become a bit of a liability. It was described by one legal academic as similar to a sort of super constitution, which it will be difficult to shake away, especially because the judgment in which it was propounded was delivered by a 13-judge bench, the largest the Indian Supreme Court has ever seen. There's much more that can be said on the subject, but I'm afraid I have run out of time. I'd been hoping that I could discuss a few more landmark cases on fundamental rights, such as the bank nationalization case, the Privy Purses case, the habeas corpus case, the cases of Menaka Gandhi and Union of India, Olga Tellis and Bombay Municipal Corporation, DK Bosu and West Bengal, etc., all of which are quite important and not necessarily in a positive sense. But that is, alas, not possible. I also wanted to talk a bit about the importance of the preamble to the interpretation of rights and about a major blemish on the preamble which continues to disfigure that part of the Constitution. But that, I fear, will have to wait for another occasion. If you let me know whether you're interested in any of those things, I'll try to incorporate them in a future episode. But for the present, I will end here and thank you, as always, for your patience in listening to me.
Dr. Swami, 1 minute.
Yes.
No, yeah, sorry.
Yeah, you can go ahead now, Dr. Swami.
No, it was unmuted now.
Okay. See, first of all, let me say that perhaps the next session we can have on 5 or 10 major judgments, what it means, whether how much you approve or disapprove, and what modifications could be suggested. If you can't do all 10 tomorrow, next Friday, next Saturday, we could have another session of 5 and 5. Because that's very interesting. Let me add one more personal note. I was a law minister for some time. And during that time, I could appoint anybody as a judge. Consultation, I took it to mean that I will inform the Chief Justice, and the Chief Justice's view would be taken, and then the final decision would be taken by me as a law minister, send it to the Prime Minister. Prime Minister, if he has a veto, if he approves, it goes to the President. President normally only issues a warrant, that is to declare that a person has been chosen as a judge. and then, of course, swearing in takes place. Of course, we had one judge who misbehaved. That was R. Venkatraman, who, despite the fact that we went through the process and all the IB checks, everything was done. It went to, and it was not when I was law minister, it was when Mr. Narasimha Rao was prime minister and Bhardwaj was law minister. And out of personal pique or dislike of the choice, the president just didn't issue the warrant for the swearing-in ceremony. Now, when you're dealing with human beings, all this happens. But what happened essentially was during the period of Mr. Hansraj Bhardwaj, who was a very fine person as a person, but extremely partisan, all kinds of people were appointed as judges who, I don't want to exaggerate, but I think even peons in the High Court who served Mr. Bhardwaj well found a place in the judiciary. So it was really a revolt. It was not a grab of power. It was a revolt to say, no, there will be a collegium, and that collegium would decide who would be finally chosen as candidates or not candidates, who will be chosen for being a judge. So I think this, your point is well taken, and the judge's point is also well taken, and somewhere we have to come to see whether we can work out a machinery where the personal discretion is down to a minimum, and perhaps even non-existent in most cases. So this is a very important aspect of the pending problem. I do think that the basic structure concept is very necessary, because you can always have a majority which says that we don't need another election for 20 years. Just now, although there is no make-believe in this, but the Chinese parliament has chosen Mr. Xi Jinping shall be the president for life. Whereas earlier on there was every 5 years you had to at least go before the parliament, whatever it is called. It was whatever name it was called by. Same thing with Putin. And there have been democracies which have been subverted by majority. It happened in Bangladesh. It's happened in many countries. So to prevent the majority changing the system itself, the democratic system, and saying that by democratic methods you have destroyed democracy, to prevent that, it had to be done. I was a member of parliament when this Gorakhnath case, and then later on the Keshavanand Bharati case was being heard, and there was a lot of lively discussion inside parliament. But we were quite afraid in the period after the Bangladesh war. Mrs. Gandhi got a huge thumping majority in many states, almost all the states of India. All the assemblies voted for Congress. And some people like Mr. Antole and all began speaking of passing a resolution to declare Ms. Gandhi as a queen of India and restore the royalty, so to speak. That is an appointment for life. And that, I think, was one that triggered the process. And it had to go through a really agonizing process where at one stage, on a fundamental issue, whether your life can be taken away in a state of emergency, only one judge stood out, and that was Justice Khanna, Hansraj Khanna, who paid a very heavy price because he was due to become in a few months the Chief Justice, and Mrs. Gandhi bypassed him. So I am sorry to take up your time, but to tell you that there is a lot of interest in what you have just been speaking. We have got chits from the audience, some of which we have put out. Greatly appreciating on a very difficult, it's a difficult subject, a bit esoteric, but you have put it very simply. So I think that's why in furtherance of that as to what our democracy really means, I think the next time we should take some 4 or 5 cases that you have just mentioned. And if you feel there are more cases also to be, then we can have another session on it. Because after all, this whole exercise that we are conducting is to educate our people and make them interested in law and not leave it to the lawyers, so to speak. Sorry for the for the what I would call as a remark on the lawyers, but I think, of course, it's a great profession, and I think teaching of law must be made compulsory in schools and colleges.
Dr. There are a couple of questions, so I'm just going to post one of them. Either of you can take this question. It says, why aren't the fundamental duties more powerful than fundamental rights?
I'll make a very brief comment and then I'll let Swami respond more. They are not powerful. They are not more powerful in law. They are not more powerful in law. Fortunately, the idea of making fundamental duties legally enforceable was abandoned even by the architects of that proposal. So, as things stand, fundamental duties cannot be enforced in the sense that nobody can go to court and say, look, I have a neighbor who does not have a scientific temper, so can we have him punished? That is just not possible. So fundamental duties are not powerful at all. That's a brief comment I wanted to make. Swami might have something to say.
No, same thing with directive principles. It's binding on the government, but no individual can go and say that why when it is mentioned in the directive principles that there should be uniform civil code, why is there no civil code? These are not enforceable by individuals. And so I think if you read in very carefully, you should have great respect for our heritage. Now that could be interpreted to mean that we are a Hindu state. I mean, I'm saying just as an extreme case. And the courts will be full of these cases. And therefore, I think fundamental duties are something that should be inculcated in schools and in examinations so that people remember them. But I don't think it can be enforceable by individuals by going to court under Article 32 of the Constitution.
No, although there is one little thing which can be done, which is that if the government makes law or policy which goes contrary to the directive principles, then that argument can be used in court as a supplementary argument. And
Sure,
so
sure.
to that extent, directive principles are useful, but there's no question of directive principles being enforced on their own by a citizen.
Yeah, I agree. It's a kind of a guiding principle.
Yeah.
If even an individual, he can quote it. Same thing with there is at least 2 judgments. I know I don't have it right here. Maybe next time when you are dealing with judgments, I'll bring that. Where it says that even duties are aids in writing a judgment for a court.
In interpretation.
Yes, that's right. And it's an additional argument. It's not the clinching argument, but it's an additional argument. So it has weight. It's not just a listing of 11 duties. It's actually something that can be taken into account by the judiciary in appropriate cases.
Yeah.
Dr. Swami, the other thing somebody just made a comment on was that it is Nani Palkiwala's 100th year or centenary year.
Yeah, that's right.
So they asked, where can Dr. Swami tell the government to give him a Bharat? Now, because he's one of the icons of the judicial part, in India. I mean, he really captivated the audience, or even the way he conducted himself. So, your quick thoughts on Nani Palkiwala?
Well, this matter had been discussed by me, incidentally, about 6-7 years ago in a group. But lawyers felt that lawyers, of course, more competitive and more jealous than any other tribe in India. So they said that it will lead to the growth of the wrong kind of lawyers. because ultimately it's the government which makes the decision as to who should get the Bharat Ratna. Jawaharlal Nehru made a decision that Patel should never get it. And you will be surprised in 1991 when I was minister and Chandrasekhar asked me who should get Bharat Ratna for the Republic Day. I was aghast to find that the name of Sardar Patel was never considered. It was brought in as a suggested name, and Jawaharlal Nehru and Indira Gandhi, both with their own hands, have crossed it out. So I think even giving Bharat Ratna to politicians is a bit risky, but there's no way of avoiding it. So, but I don't think lawyers should be given Bharat Ratna for this purpose. But I do think that some of them, for instance, when I was minister, I gave Fali Nariman Padma Vibhushan, the one below the Bharat Ratna, and very few people get Padma Vibhushan, and he got it, and he has done tremendous. I mean, after Palkiwala, I would consider him as the most outstanding lawyer that we have produced.
The other thing, again, Venkat, this is your subject that is close to you, which is privacy, that we're just showing on the screen.
Yes.
Basically, I mean, given where we are today with all the electronic world and social media, but everything is out in the internet. So, should we make individual privacy a fundamental right? How is it compared to the world?
I'm actually very disappointed with the way the right to privacy has been treated by the Supreme Court of India. And I'd actually planned to do a separate session because it is becoming even more important than it was, say, even a year ago. And really the idea of saying, anything and everything is part of the right to life, which is the approach that the Supreme Court has been taking in the last few years, does create huge problems in the long run. Now, temporarily, it may sound good, it may make people feel good, but concepts like privacy are not very easy to deal with in law. So one has to be very careful when you lay down guidelines of a binding nature. So the short answer is individual privacy is important, but it cannot override other competing interests. And I'm more than happy to talk about it at length.
Okay. We'll do another.
Two of the topics I wanted to deal with at length were defamation and individual privacy, and possibly even contempt of court, now that is becoming quite topical in India as well. So if we do have the time, I don't know for how long this series will go on, but if we do have the time, I want to devote probably an entire session to that kind of topic.
Yeah, we'll do this. Definitely we'll do.
Let me add one thing, just in a lighter vein. We have refused to enact a law against marital rape, saying that's invasion of privacy.
Yeah.
Amazing. So quickly, I know you did touch upon the subject of the collegium system of judges appointing themselves, where every other seat to power in the highest, even at the highest level, goes through some kind of a voting process. But for that, is there? I know it's a very touchy subject. The council was brought in, and there was a controversy around it. It just amazes me that even today, I mean, if you take the US, if some judge, a lot of judges here at local level are getting elected, and something like there is some process to which it's not only the judges that elect themselves. There should be somebody else from the outside also have some stake or say in who needs to sit who need to be elected or selected as judges. So just a few thoughts on that, so that we can close the session for today.
Before he speaks, let me give an anecdote on that. Anecdote.
Yeah, go ahead.
Again, as a law minister, I had drawn up a list of people who should be made judges, and one of them, the Intelligence Bureau, turned it down and this was brought to my notice by the then Chief Justice, that you may consider not making him a judge. I mean, there was nothing else the Chief Justice could do except to say to me this. Now, when I checked with some of my lawyer friends, they said no. The things what the Intelligence Bureau report said was that he was a womanizer, he was a corrupt man, he's this, that, he's produced many children which are not legitimate, and so on. And so I asked a friend of mine who's a lawyer. He said, no, he's nothing of that kind. He's a very upright, decent person. So I called the IB chief, M.K. Narayanan, at that time, and asked him to personally do a check. And he came back and he said, this report of the IB was, and was the director of the IB, he said the report of my agency was utterly false. And so I set it aside, but I asked him, how could anybody do this? So he said, you see, our system, we had just allotted it to an ordinary IB officer and a very low-level officer. And he would be wined and dined, and because there are bar, contests, the bars are also in groups. The lawyers are also functioning as groups. So if a person is nominated by one group, then the other one, gets the wines and dines this intelligence officer, and then he writes the report, which they want. And so it became very dangerous. And then that judge became so good that it was a high court appointment, and he went to become chief judge, went to become Supreme Court judge, and he is now, till very recently, I think he's still there, but I'm not sure, he's on the International Court of Justice. So imagine, I mean, I can give you this name because this is a close conversation, Dalbir Bhandari. So the finest person, a man of great, and an IB report like that came. So these judges' appointments so crucial, but look at the amount of personal animosities and things that come in. So we have to really think very, very hard before we prescribe a system. Anything?
Two things which I would guard against when it comes to judicial appointments. Now, incidentally, judicial appointments is not an easy issue for anybody to deal with, whether it's a government or whether it's a bar or any other body. There's no perfect system. You will have to some extent to take these things on trust. But two things which I would avoid are, first of all, subjecting judges to elections. That can be disastrous because it'll become very little from a political fight. Secondly, quota system for judges. That is another thing which is going to destroy the judiciary.
I was about to ask you that question.
Sadly, in my own country, in the UK now, we are gravitating slowly towards an informal quota system. It's not yet formalized. So what happens is there is always a push for having one ethnic minority, one black, one Muslim, one homosexual. That sort of a thing is really going to destroy the integrity of the judiciary as well as its independence. So the short answer to your question, Ramesh, is that I do not favor voting or elections for judges. Definitely not.
Okay. Yep. Yeah, because my other question, because in India, I mean, luckily we still don't have the challenges you have in UK in terms of having a balanced court. But at least the caste system comes into play, saying, you elected, you didn't put so many Dalit judges here. And what, I mean, you're a judge. What does it mean whether you're a Dalit or a forward or a backward or a scheduled caste? How does it matter? When you sit on the table, on the chair, it really doesn't matter what you are. I mean, it's become so polarized, or even that, in as much a bias creeps in, even when you're sitting at a Supreme Court judge, which we have seen in many cases. So the bias does creep in. It's just shameful that, we have not come across, even after 70 years. I mean, they rot us in, but at least 70 years is a long time for us to rethink this whole process of, it has not gotten where we are. That's all I'm saying. It's just a very good laws, constitutions, but unfortunately, the number of cases on. We need to come up with a better way of selecting judges because it just becomes very difficult. Thank you. Jagdish ji, go ahead. Sorry.
Yeah, thanks, Dr. Venkat Iyer and Dr. Swamy for this informative session. We are running out of time, and as Dr. Swamy and Venkat agreed that we will be having to discuss certain case laws in next sessions, depending on how we structure the program. Each session is becoming interesting, and there's a lot of queries and questions and other issues. Some may be relevant directly to today's topic, but some are already discussed in the past, or some can be discussed in the future session, depending on the topics we take up. So with this, we end today's legal words of wisdom, that is Nyay Gyan Ganga. And I would request viewers, if you have any question, to send it to legalwordsofwisdom@gmail.com, legalwordsofwisdom@gmail.com, and Dr. Venkat Iyer and his team would respond to some of these questions. So here it is on the screen, legalwordsofwisdom@gmail.com. So with this, we end our program. We will be back tomorrow with our regular Sunday program at 8 p.m. Indian Standard Time. And tomorrow's topic is, should government be controlling Hindu temples? This is our topic. Dr. Subramanian Swamy and T.R. Ramesh would be discussing this topic. So do keep in tune tomorrow, Indian time, 8 p.m. for another interesting episode of Gyan Ganga. Now we will be back with our legal Gyan Ganga on next Saturday, that is in the first Saturday of November, with Dr. Venkat Iyer and Dr. Subramanian Swamy. So I thank all our viewers, our friends, and all our team for their support for putting this program together. Jai Hind and Dhanyavad, and thank you.
Yes.
Thank you.